Okay, good evening. Can you hear me?
Good evening, Attorney.
Yes, Attorney. Good evening.
Thank you. We are already done with Rule 110, and this evening we will start discussing Rule 111 of the Rules of Court, Rules of Criminal Procedure. Now, let's start with reading the provisions of sections. Sorry. Ako lang mo in-mute ha. Wait lang kay magsapaw ta. Okay. All right. Sige. So we will read first the rule and then we will now discuss dayon kung unsay pasabot aning rule. Let's start with section 1 of Rule 111, the institution of criminal and civil action. Section 1 provides that when a criminal action is instituted, the civil action for the recovery of the civil liability arising from the offense charge shall be deemed instituted with the criminal action. Tanawa ha, when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charge, take note of this phrase, arising from the offense charge shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserves the right to institute it separately, or institutes the civil action prior to the criminal action. Basically, the general rule is that kung mag-file ka og criminal case, it follows with it the civil liability arising from that criminal case. The exception only is that kaning tulo, if the offended party waives the civil action, kung yang gi-waive, or iyang gi-reserve ang right to institute it separately, or he instituted the civil action prior to the criminal action. Ato nang tagsa-tagsaon later. Next paragraph, the reservation of the right to institute separately the civil action shall be made before the prosecution starts presenting its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. When the offended party seeks to enforce civil liability against the accused by way of moral, nominal, temperate, or exemplary damages without specifying the amount thereof in the complaint or information, the filing fee thereof shall constitute a first lien on the judgment awarding such damages. Where the amount of damages other than actual is specified in the complaint or information, the corresponding filing fee shall be paid by the offended party upon the filing thereof. Except as otherwise provided in these rules, no filing fee shall be required for actual damages. No counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case, but any cause of action which could have been the subject thereof may be litigated in a separate civil action. That's only the first paragraph of section 1. Now let's go to the second or the subparagraph B of section 1. Here, it states that the criminal action for violation of BP bilang 22 or Batas Pambansa bilang 22 or the Bouncing Checks Act shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. Tanawa ha. Balik, the criminal action for violation of BP bilang 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. And then upon the filing of the aforesaid joint civil and criminal actions, the offended party shall pay in full the filing fees based on the amount of the check involved, which shall be considered as the actual damages claimed. Where the complaint or information also seeks to recover liquidated, moral, nominal, temperate, or exemplary damages, the offended party shall pay additional filing fees based on the amounts alleged therein. If the amounts are not so alleged, but any of these damages are subsequently awarded by the court, by the filing fees based on the amount awarded shall constitute a first lien on the judgment. Where the civil action has been filed separately and trial thereof is not yet commenced, it may be consolidated with the criminal action upon application with the court trying the latter case. If the application is granted, the trial of both actions shall proceed in accordance with Section 2 of this rule governing consolidation of the civil and criminal actions. Wait lang, naagi naka-unmute. Ano sa man to? All right. And now on to Section 2 of Rule 111. This pertains to the suspension of the separate civil action. Ako ning basa tanan up to Section 3 aron ang atong discussion diretso-diretso na. Section 2 provides that after the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. Okay? If the criminal action is filed after the said civil action has already been instituted, the latter shall be suspended in whatever stage it may be found before judgment on the merits. The suspension shall last until final judgment is rendered in the criminal action. Nevertheless, before judgment on the merits is rendered in the civil action, the same may, upon motion of the offended party, be consolidated with the criminal action in court, trying the criminal action. In case of consolidation, the evidence already adduced in the civil action shall be deemed automatically reproduced in the criminal action without prejudice to the right of the prosecution to cross-examine the witnesses presented by the offended party in the criminal case and of the parties to present additional evidence. The consolidated criminal and civil action shall be tried and decided jointly, and during the pendency of the criminal action, the running of the period of prescription of the civil action which cannot be instituted separately or whose proceedings has been suspended shall be tolled. And then the extinction of the penal action does not carry with it the extinction of the civil action. However, the civil action based on delict shall be deemed extinguished if there is a finding in a final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist. And then finally, let's have Section 3 of Rule 111. In cases provided for in Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines, I suggest inyo ni ukayon kung unsa ni sila ha. The independent civil action may be brought by the offended party. It shall proceed, so mauni ang instances wherein civil action may proceed independently. Okay? It shall proceed independently of the criminal action and shall require only a preponderance of evidence. In no case, however, may the offended party recover damages twice for the same act or omission. Okay? So let's now discuss. I hope na ba mo'y kopya aning codal provisions? Guys?
Naara man, attorney.
Naara no? Sige, okay. So, timan nga ato na ning ginisgutan in passing before nga kung naay criminal action nga i-institute, the civil action for the recovery of the civil liability arising from the offense charge shall also be instituted with the criminal action. That's the general rule, okay? Timan i-here nga that the civil action deemed instituted with the criminal action is that which arises from the offense charge. Later on, akong ipakita ninyo nga dunay nagkalain-lain nga sources of obligations. And one of the sources of obligations are those obligations arising from delicts or criminal actions. So kung ang obligasyon, ang imong civil obligation arose from criminal liability, necessarily ang civil liability pud nimo is that which arose from the criminal liability or of the offense charge. So timan nga kani general rule pertains to the civil liability arising from the offense charged. Okay? So ang ma-deemed instituted with the criminal action is the civil liability arising from the offense charge. Okay? Now, if nakarecall sad mo, ato po nang nahisgutan before, ang principle nga ang criminal case or ang every person who is criminally liable is also civilly liable. Mula na yung timanan. That's under Article 100 of the Revised Penal Code. So if naakay criminal liability, there is also an accompanying civil liability. All right? We also discussed before nga ang rason ani nga prinsipyo sa balaod is because of the traditional theory that when a person commits a crime, he offends two entities. Ang una ang state, ang ikaduha ang private individual, okay? He offends first the society in which he lives in or the political entity called the state, whose law he has violated. And the second one is the individual member of that society whose person, right, honor, chastity, or property was actually or directly injured or damaged by the same punishable act or omission. Now, the civil action in which the offended party is the plaintiff and the accused is the defendant is deemed instituted with the criminal action unless under this paragraph, first paragraph of section 1, unless he waives the civil action, he reserves the right to institute it separately, or institutes the civil action prior to the criminal action. So, ang balaod nag-allow for the merger of the criminal and civil actions to avoid multiplicity of suits, okay? So, when the state succeeds in prosecuting the offense, the offended party benefits from such result and is able to collect the damages awarded to him. The court further explains that when the accused is acquitted or when the case against him is dismissed for failure of the prosecution to prove his guilt beyond reasonable doubt, the civil action is not automatically extinguished since the liability of the accused can be determined by mere preponderance of the evidence. You should also remember that the degree of liability when it comes to criminal cases is proof beyond reasonable doubt. Now, niingon ng jurisprudence nga kung ma-dismiss ang criminal case, it doesn't necessarily mean nga ma-dismiss pod ang civil case because ang degree of liability required in criminal case is only a mere preponderance of evidence as opposed to a criminal case nga proof beyond reasonable doubt. Okay? So, inyo sa natimanan nga principle. Now, unsa man day purpose why naay criminal action o naasay civil action? According to the case of Recarze versus Court of Appeals, the prime purpose of criminal action is to punish the offender in order to deter him and others from committing the same or similar offense, to isolate him from the society and reform and rehabilitate him, or in general, to maintain social order. On the other hand, the sole purpose of the civil action is for the resolution, the reparation, or indemnification of the private offended party for the damage or injury he sustained by reason of the delictual or felonious act of the accused. Now, you should also remember that because ang civil action is impliedly instituted with the criminal action, kung naagani kaso nga i-file sa court, the trial court should, in case of conviction, also include the liability or damages caused by the wrongful act or omission to be recovered by the accused or from the accused by the offended party, if there is any, and if the filing of the civil action has not been reserved, previously instituted, or waived. So, kung dunay conviction ang trial court for a criminal action since impliedly instituted man ang civil action, kailangan sa decision sa korte ibutang niya ang civil liability or damages nga pagabayaran ni offended party or ni accused nga kang offended party kung wala ba na niya gi-reserve ron or previously instituted or waived ang iyang right to the civil action. Now, kanus ato gani nga pwedeng mo proceed independently ang civil action? Ganiha ato tong hisgutan no, a single act or omission that causes damage to an offended party may give rise to two separate civil liabilities on the part of the offender. Akong gi-emphasize ganiha nga there are different sources of obligations. So kung dunay act or omission that actually causes damage to an offended party, this could actually produce two separate civil liabilities on the part of the offender. Pwedeng civil liability arising from the crime o independent civil liability. Mauna ang civil liability that may be pursued independently of the criminal proceedings, which inyo nang may waan ron. Kung kag civil liability arising from the offense charge or civil liability ex delicto, this is the civil liability arising from the criminal offense under Article 100 of the Revised Penal Code. Kana sige na to balik-balik. Ang ikaduha nga civil liability is kaning independent civil liability. Mao ni ang civil liability, as I've said earlier, that may be pursued independently of the criminal proceedings. Now, the independent civil liability may be based on an obligation not arising from the act complained of as a felony, as provided in Article 31 of the Civil Code, such as kanang breach of contract or for torts, okay? It may be also be based on an act or omission that may constitute a felony but nevertheless treated independently from the criminal action by specific provision of Article 31 of the Civil Code, kana in cases of defamation, fraud, and physical injuries. The civil liability arising from the offense or ex delicto is based on the acts or omissions that constitute the criminal offense. Hence, this is inherently intertwined with the criminal action. And for this reason, the civil liability ex delicto is impliedly instituted in the criminal offense. On the other hand, ang independent civil liabilities are separate from the criminal action and may be pursued independently as provided for in the Civil Code, particularly Articles 31 and 32. Ang rules of court mismo giklaro kung unsa ang mga pwedeng i-institute nga criminal action separately. Okay? Under the rules, only the civil liability of the accused arising from the crime charged is deemed included in a criminal action. Thus, civil actions referred to in Articles 32, 33, 34, and 2176 of the Civil Code shall remain separate, distinct, and independent of any criminal prosecution which may be based on the same act. Kiba ko naglibog na mo? I'll try to illustrate it ha. Kung saan to ni paggamit ang whiteboard. Wait lang. I'll stop share. Whiteboard. Nakita ang whiteboard, guys?
Yes, attorney.
Yes, attorney.
Yes, attorney.
Okay. So if let's say si Juanito nakakommit siya og crime. May text B. He commits a crime. Let's say, for example, the crime committed by Juanito is butang talang physical injuries. Okay, physical injuries. Question, how many civil liabilities can you actually institute against Juanito? Guys. Kung si Juanito nakakommit siya crime against, let's say, Akim for physical injuries, okay? Pila ang civil liability nga pwede nimong ma-file against Juanito?
Recovery sa kuan attorney kanang
I think
2, attorney.
recovery.
civil and criminal. Civil and criminal.
Okay, you already have, diba? Physical injuries is already a criminal offense, correct? So criminal offense na ni. Criminal action. So ang general rule based on Rule 111 Section 1 is that if you file a criminal action against Juanito, naapoy corresponding nga civil action nga ma-deemed institute against niya, di ba? So kaning criminal action already has a civil action. Sakto?
Yes,
Civil liability, yes.
Unsa man ni siya nga klase nga civil action? Arising from?
The
From the
criminal
crime
offense.
committed.
Yes.
Civil
Yes.
action.
The crime committed.
Arising mismo from this criminal action, di ba? Or this is civil action or civil liability ex delito, or meaning civil liability arising from the offense charge, the criminal action which is the physical injuries, correct? Now, pwede pa tang mo file niya og separate or independent and separate civil action arising from the injuries nga iyahang gi-incur ngadto kang kinsa to yung nasan-an kang Akim?
Yes, pwede.
I think attorney
Depende
we should
siguro
not
attorney kung
because
unsa nga
we can-
klase sa physical injuries na.
attorney, di ba naman tayo double jeopardy? I think we cannot file another case for that.
Ang gasto de attorney sa physical injuries yan pagpa-doktor.
We can file, attorney, according to Article 2176 of the Civil Code, attorney.
Independent civil action.
Unsay basis na to?
Article 2176, attorney, of the Civil Code.
2176?
Yes,
Let's
attorney.
try. Okay. Tanawa ko na ninyo inyong Section 3, Rule 111.
When civil action may proceed independently. Yes, 2176 na siya sa Section 3.
Unsa may naa sa 2176?
the independent civil action may be brought by the opponent party requiring preponderance of evidence, attorney.
Unsa may provision in 2176?
Ay.
2176, whoever by act or omission causes damages to another, there being fault or negligence is obliged to pay for the damage done. So such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delect and is governed by the provisions of this chapter. Attorney.
Okay, sige. What if, how about Article 33 of the Civil Code? What does it provide?
Civil Code.
In cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and distinct from criminal action may be brought by the injured party. Defamation, fraud, and physical injuries, attorney.
Okay. So, unsa may basis nato for the independent and civil action that you will file against Juanito in this case?
Defamation or fraud.
The quasi-delect and the other ones, the
Article 33. Ang quasi-delect.
Article 33. Article
2176, attorney, and Article 32, 33, 34.
Okay. So ang rules mismo guys nag-clarify nga ang deemed instituted ra nga civil actions in the criminal prosecutions are those civil actions or criminal liability arising from the crime charged. Okay? So kung when Akim would file a case against Juanito for criminal action of physical injuries defined and penalized under the revised penal code, kani nga criminal action would deem include the civil liability of Juanito arising from this particular criminal action. Okay? Unya, under pod sa inyong Rule 111, Section 3, pwede si Akim mo proceed independently and separately for the case of damages or civil liability arising from Article 33 of the Civil Code. Okay? Which is nag-state nga, unsa to giingon sa Article 33, nga in cases of defamation, fraud, physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. And such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Okay? Mayong mo niya, attorney, duha na ang liability ni Juanito magdubli iyang bayad. Ningon po ang balaod nga provided nga there is no double recovery. So kung naka-recover na siya og civil liability from this case, di na siya ka-recover og doble from this case. Okay? Kakuha mo guys, mauna ang naasa rules. That is the concept of separate and independent civil action. But you need to remember nga gi-specify sa Rule 111 Section 3 kung unsa ni ang mga kaso nga pwede nimong mo proceed independently and separately from the criminal action. Unsa man ni? Nag-una ani ang Article 32 of the Civil Code. Unsa may giingon sa Article 32 of the Civil Code? Who can tell me? Medyo taas-taas. Article 32 of the new Civil Code. Kinsa may makabasa pwede? Palihog, Article 32. Maunay first one. Nga pwede proceed independently. Yes, Kate.
Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. So 1, freedom of religion. Next, freedom of speech. Freedom of right for the press or to maintain a periodical publication. Freedom from arbitrary or legal detention. Freedom of suffrage. Right against deprivation of property without due process of law.
Kadyo sakit ha. Na-discuss na ba ninyo ang Bill of Rights?
Wala pa, attorney.
Unsa pa
Wala
inyo?
pa.
Government?
Rag sa Constitu na siya, attorney.
So government mo ang konsiwan, no? You are
Yes, attorney.
discussing the 3 branches of the government. Mo na inyo haron?
I-discuss pa, attorney. Yes, attorney.
Okay. Sige, sige.
People pa mi next, attorney.
Next time pa di ani. Okay, sige padayon Kate palihog.
6, the right against deprivation of property without due process of law. 7, the right to adjust compensation when private property is taken for public use. 8, the right to equal protection of the law. 9, the right to be secure in one's person, house, papers, and effects against unreasonable searches and seizures. 10, the liberty of abode and of changing the same. 11, the privacy of communication and correspondence. 12, the right to become a member of associations or societies for purpose not contrary to law. 13, the right to take part in a peaceable assembly to petition the government for redress of grievances. 14, the right to be free from involuntary servitude in any form. 15, the right of the accused against excessive bail. 16, the right of the accused to be heard by himself and counsel to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witness face to face, and to have compulsory process to secure the attendance of witness in his behalf. 17, freedom from being compelled to be a witness against oneself, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession, except when the person confessing becomes a state witness. 18, freedom from excessive fines or cruel and unusual punishment, unless the same is imposed or inflicted in accordance with the statute, which has not been judicially declared unconstitutional. And 19, freedom of access to the courts. In any of these cases referred to this in this article, whether or not the defendant's action or omission constitutes a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages and for other relief. Such civil action shall proceed independently of any criminal prosecution and may be proved by a preponderance of evidence. The indemnity shall include moral damages. Exemplary damages may also be adjudicated. The responsibility herein set forth is not demandable from a judge unless his act or omission constitutes a violation of the penal code or other penal statute. That's it, attorney.
Okay, thank you, Kate. If you notice, if you have browsed through your Bill of Rights, kaninga Article 32 is actually a violation of the rights enumerated in Article 3 of the 1987 Constitution or the Bill of Rights, okay? So if your rights are violated, the rights enumerated in Article 3 of the Philippine Constitution is actually violated by any person, either a public officer, employee, or a private individual. Your right may be to file a case for damages against the said person. So whether under aning article, whether there is a corresponding criminal liability, kung naay corresponding criminal liability, there is also a civil liability, and you can also file a separate civil action arising from Article 32 of the new Civil Code. So kaniha timan these are actually rights enumerated in the Bill of Rights or Article 3 of your 1987 Constitution. Now, let's proceed kuno basa sa Article 32, Kate. 33, Kate. Palihog, Kate.
Okay, attorney. Article 33. In cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and distinct from the criminal action, may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence.
Okay. Timani ang kaning defamation, kaning fraud, physical injuries, these are actually offenses punished under the revised penal code. May yung kag defamation, this could either be oral defamation or libel. That's another form of defamation. Or you can also have fraud. Kaning fraud mo ning estafa. Okay? Ang physical injuries mo ning either slight, serious, or less serious physical injuries. You can file a criminal case as well as civil liability arising from that criminal action. You can also file an entirely separate and distinct civil action apart from that of the criminal action nga inyuhang gi-file against the accused. Okay? And this is so because lahi magod ang klase sa lahi ang weight of evidence nga gi-require when it comes to civil liability. Kani dayang damages nga inyong i-file here is only a civil case. So the weight of evidence that is required is only that of preponderance of evidence. Kung may kag preponderance of evidence, kung imong timbang-timbangon, kinsay mas bugat ang ebidensya, that's basically preponderance of evidence. But when it comes to criminal action, what is required is proof beyond reasonable doubt. Kailangan ang evidence nga imong gi-present against the accused, wala gyoy bisan gamay nga reasonable doubt. Otherwise, it may be dismissed and the accused may be acquitted from his liability. Okay? Now, what is the provision in Article 34, Kate? Tiwaso na to, Kate. Article 34. Timanin na ninyo ha. 32, 33, 34, and Article 2176. You can file an independent civil action out of these cases. So, Article 34, Kate, please.
Okay, Article 34. When a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger of life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefore. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action.
Oh. So lahi pud ni siya ha. This pertains to the police force kung mo fail mo og render og aid or protection to any person in case of danger of life or property. So basically, ang police officer siya ang primarily liable for damages. Unya kung insolvency or wa siya kwarta, ang city or municipality kung asa siya na under will be subsidiarily liable, meaning maoy mo bayad on his behalf. Unya, klaro sa dire in your second sentence nga the civil action herein recognized shall be independent of any criminal proceedings and a preponderance of evidence shall suffice to support such action. So 32, 33, 34. How about 2176? Kate, palihog ko. Na kay 2176 decade?
Wala, attorney. Sorry, attorney.
Attorney?
Kinsay na Si?
Article 2176.
Okay. Proceed, please.
Yeah, okay, so Article 2176, whoever by act or omission causes damages to another, there being fault or negligence to oblige to pay for the damages done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provision of this chapter.
Okay. So example aning quasi-delict guys, kana ganing mga disgrasya nga reckless imprudence resulting in, let's say, serious physical injuries. For example, na ay common carrier, unsa may inyong mahunahunaan ng common carrier, let's say jeepney, okay? Driver sa jeepney, because negligence siya, nakakos siya injury sa usa ka pedestrian, iyang naligsan, okay? So in this instance, under Article 2176, Si driver sa jeepney is not only civilly liable as a result of the serious physical injuries nga iyahang na-cause ngadto sa pedestrian, but he is also liable under a quasi-delict or culpa aquiliana pursuant to Article 2176 of the Civil Code. So kani nga liability bisan pa og resulting from the same negligent act is separate and distinct from the crime. So later on ako ipakita ninyo nganong daghan makayo nag sources of obligation ang usa ka tawo nga makasa attorney, because under your law on obligations and contracts there are different sources of obligations, and as long as ang balaod ni ingon nga you can actually proceed independently when it comes to this particular case, well, you can really proceed with that particular case. Timan ilang ang articles 32, kung sa ganitong 32 mao ni ang katong
Bill of Rights.
Bill of Rights, violations of Bill of Rights. Ang 33 unsa gani ni?
Defamation, fraud, physical injuries.
Okay, very good. Ang 34, katong failure on the part of the police officer to aid and protect, yes, a citizen. And then ang 2176 mao ni gitawag natong quasi-delict or culpa aquiliana. Naamoy subject ani guys nga torts and damages in your, I think, second year. Inyo ni extensively ma-discuss niya later. But for purposes of this subject, para makahibaw mo sa concept sa independent civil action, timan under Rule 111, Section 3 of the Rules of Court, Articles 32, 33, 34, 2176 may proceed independently from this civil action, okay, nga arising from the criminal action. Now, remember that the civil actions arising from Articles 2176, 32, 33, and 34 of the Civil Code may be filed independently and separately from the criminal action because they do not arise from the offense charged. What the law actually prohibits is double jeopardy, di ba? Bawal ang double jeopardy. But in Article 2177 of the Civil Code, it declares that the plaintiff cannot recover damages twice for the same act or omission of the defendant. The same prohibition on double recovery is also reiterated in your Section 3, Rule 111, when it says that in no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. Bisan pa og makafile ka independently and separately og civil action arising from other sources of obligations, timan nga you cannot recover damages twice for the same act or omission charged in the criminal action. So kung gi-awardan na kag 1 million sa imuhang independent civil action, di naka-awardan og another 1 million in your civil action arising from the offense charge. Unless kung ang gi-award diri sa PICAS is 2 million na ay deficit sa other nga 1 million. So ang imo na lang ma-recover, pananglitan, ang gi-award sa imong independent civil action is only 1 million. But in the civil liability arising from the offense charge, katong arising from the crime or the criminal action, gi-awardan dito og 2 million damages. So ang mahitabo is imuhang didakan. So ang makuha na lang nimo from the civil liability arising from the offense charge is only 1 million. There's no double recovery because in this particular case, sa PICAS nga kaso, 2 million man ang gi-award. Okay? But if the same lang at 1 million, 1 million, meaning ang form of damages nga gi-determine sa court is only 1 million, there can be no double recovery. Hence, ang imurang makuha nga 1 million is that 1 million awarded in your separate and independent civil action nga imuhang gi-file. Okay? Now, let's go to the sources of obligation. Ang obligasyon sa katao mo arise either from law, balaod mismo ang niingon na naa kay obligation. Ikaduha, wait, let me share my screen. So as I've said earlier, there are different kinds of sources or different sources of obligations. Okay? So una ani ang law, ang balaod mismo nag-ingon nga you have an obligation. The obligation here is that which imposed by law. Okay? Ikaduha, contracts. Kontrata. Ikatulo, quasi-contract. Ikaupat, acts or emissions punishable by law. And then ikalima, ang quasi-delicts. Now, when we talk about law as a source of obligation, the obligation here is imposed by law. Example, ang obligation sa usa ka bana og asawa to support the family. Di man na ingon nga nagsabot-sabot mo or balaod na siya sa out of tradition. This is actually an obligation imposed by law. So your obligation to support the family is an obligation arising from law. Okay? Now, contracts. Doon na po kay obligasyon nga nag-arise sa contract. Kaning when both parties actually agree or their obligation actually arise from the stipulation between the parties. So, kung panalitan ako, nanguham kong kwarta kang Kate, ako ang obligasyon nga to kang Kate based on the kontrata is to repay the money that I borrowed from Kate. Okay, by virtue of the agreement. That is actually my obligation arising from contract. So, kung panalitan mo default ko sa pagbayad sa akong utang adto kang Kate, mukiha si Kate, ang iyahang basis sa iyahang pagkiha nako is the contract. Okay? The obligation that is the basis of the case filed by Kate is that of contract. Katong amo ang agreement nga gisabutan nga mobayad ko sa akong utang kang Kate. Okay? Doon na po tayo sources or source sa obligation that is called quasi-contract. Kung may quasi-contract, there is a judicial relation arising from certain lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other based on the principle that no one shall be unjustly enriched or benefited at the expense of another. Later on, makabawsad mo nga na ay duha ka klase ang quasi-contracts kaning gitawag na tog solutio indebiti o negosyorum histio. Nakasugat na ba mo ano yung concept guys kanang solutio indebiti?
No, attorney.
We haven't, attorney.
Okay. In quasi-contracts, na duha ka konsepto ana. Ang una is the solutio indebiti or unjust enrichment and the negosyorum histio. Nagyapon ni siya sa civil code guys. Kung mayong ka og solutio indebiti, ang nahitabo here is na kay na-receive nga usa ka butang apan wa kay right to demand it and it was delivered to you through mistake. Example, nimpliti ka ron og 20. Unya ang pliti, pila na ba pliti ron minimum?
15.
May mag-commute diri. 15? 15?
Kibol. Impikan.
15, attorney.
15. Let's say ang minimum ron 15. Pliti kag 20, 15 ang minimum, apan gisuklian kag GIS. Okay? Doon na ba kay katungod nga mo receive sa GIS?
Sa 5 siguro, sa 5 attorney.
Yes.
Okay?
Pwede.
By virtue, yes. By virtue of the principle of solutio indebiti under quasi-contract, guys, doon na kay obligation to return the excess of pila? 5 pesos. Because ang imuha ramang katungod nga ma-receive as a sukli is only 5 pesos. So gatuon mo nga based ranis konsensya atuwa nga tuwa ni uli ang 5 nga sobra sa gisukli ni manong driver. No. Under the law, under quasi-contracts, na agyunis balawdo, kung nagbutbutan, awala yan ninyo. Nga under solutio indebiti, you have the obligation to return the 5 pesos in excess sa sukli ni manong driver. Because wa man kay katungod nga mo receive it and it was unduly delivered to you through mistake. Okay? Another example, pananglitan, empleyado si Kate ni Glenn. Okay? Unya, dunay gibayad ngadto kang supposedly para kang Kate nga let's say 10,000 pesos for the service nga girender ni Kate. But dito gihatag kang Glenn. So ang obligation no ni Glenn is to give the amount of 10,000 pesos ngadto kang Kate. Kasi Kate may nagtrabaho, dili man si Glenn. That's actually basically the concept of solusyo in DBT. But the very common example ana kanang masubraan tag sukli. Okay? Ayaw yung tao mong kalipay nga nasubraan mong sukli because under the principle of solution in DBT, you have the obligation to return it. Okay? So mo nang first form of quasi-contract. Ikaduha is kaning negosyorum histio. Okay? Ang negosyorum histio exists when one voluntarily takes charge of an agency or management of a business or property of another without any power from the latter. Okay? So example ani kung si Kate, caretaker, sa balay nga for rent, received an amount of more than the boarders due, si Kate ani, without the power of the owner of the house, increase the payment which is not due to the boarders. So si Kate has the obligation to return the money paid which is not due to the boarders. Di siya pwede nga magbuot-buot o increase, let's say, ang abangan ra ron sa mga boarders nga gipabantayan sa yaha as the caretaker is only 5,000. Unya nagbuot-buot siya og increase into 10,000. By virtue of negosyorum hestio, si Kate has no right to actually increase the payment of the boarders. And his obligation is to return the money nga gibayad sa boarders if musubra ang ilahang gibayad. Okay? That's basically the concept of quasi-contracts. Walay kontrata pero mura-murag kontrata. Okay? Mao nang quasi, mura-mura. So quasi-contracts. Now the fourth source of obligation is after emissions punished or punishable by law. So mao ni siya atong gisgutan ganiha nga civil liability arising or as a consequence of criminal offense committed. So kung panalitan si kisa to example ganiha si Akim, si kisa matong nangulata ganiha si
Juanito.
Let's say for example si Juanito nangulata kang Akim and caused physical injuries ngadto kang Akim, si Akim will be responsible for the payment of all the medical expenses and the damages to Akim. Okay? So si Akim here has the obligation for the payments of the medical expenses and the damages in favor of Akim. Okay? So muna ang acts or omissions punishable by law. This is actually the liability of an individual kung duna siya makumit nga crime or offense under the revised penal code or other special penal laws. Mooning acts or omissions punishable by law. Okay? And then the quasi-delicts katong atong gihisgutan in 2176. 2176 quasi-delicts arise from damages caused to another, there being fault or negligence. Ang keyword ana fault or negligence, giving rise to the obligation to pay the damage done. And there must be no pre-existing contractual relation between the parties. Okay? So kung panalitan si Akim, napaakan siya ron og Rottweiler, kung ako'y tag-iya sa Rottweiler, akong obligation is to pay the injury caused to Akim because gipaak siya sa ako ang iro. That's actually quasi-delict or tort. My obligation arose from quasi-delict. Because of my negligence, because of my fault, kaya akong gipasagdan akong iro, napaakan si Akim, so my obligation is to pay the damages caused to Akim, okay? Or the injuries nga nahitabo kang Akim because of my dog. So basically, these are the sources of obligation that you need to look into. Mao nang mayon siguro mo nganong na may independent civil action, mo ni naglibog mo sa concept, but timani nga ang hisgutan nato diri nga deemed instituted na civil action is the civil action that arose or that actually arose out of the acts or omissions punished by law or katong ex delito. Okay? Ex delito. If ang law niingon nga you can proceed independently and separately based on the enumerated articles provided in Section 3, Article or Rule 111, katong 32, 33, 34, and 2176, muna to siya ang arising from the law and quasi-delex. Katong 32, 33, 34, ang source of obligation ato law ha. Unsa nga law? The new Civil Code of the Philippines, particularly Articles 32, 33, and 34. Kung maingon ka katong 2176, unsa imong source of obligation ato? Kaning number 5, quasi-delex. Okay? Timan nila na ninyo. I hope kuha ra na ninyo, pero I hope nagbasa sad mo sa inyong book. Okay? So unsa may consequence of the independent character of actions under Articles 32, 33, 34, and 2176 of the Civil Code. So here are the consequences of the distinct and separate character of the civil actions arising not from the offense charge, but from Articles 32, 33, 34, and 2176 of the Civil Code. Una, the right to bring the civil action shall proceed independently of the criminal action and regardless of the results of the criminal action. Okay? Ikaduha, the quantum of evidence required in these instances is only preponderance of evidence. Preponderance of evidence. Ikatulo, the right to bring the foregoing actions based on the Civil Code need not be reserved in the criminal prosecution since they are not deemed included therein. Ha? Timan, di na mo kailangan i-reserve, di na kailangan maingon sa court nga, Your Honor, I reserve my right to file an independent civil action because they are not deemed included in the criminal action. Kaya ang deemed included raman sa criminal action, katurang general rule, di ba? What is deemed included gani guys in the criminal action? Those are the civil liability arising from the
action.
Offense charge.
From the offense charge. That's correct. Okay? So timan nga the right to bring the foregoing actions based on the Civil Code need not be reserved in the criminal prosecution since they are not deemed included therein. And then the institution or waiver of the right to file civil action or separate civil action arising from the crime charge does not extinguish the right to bring an independent civil action. Precisely because lahi na siya, separate na siya, okay? And even if a civil action is filed independently, the ex delicto civil liability in the criminal prosecution remains, and the offended party may, subject to the control of the prosecutor, still intervene in the criminal action in order to protect the remaining civil interest therein. So pwede gid kaayo nga mo proceed na together or simultaneously ang independent civil action as well as the civil liability arising from the offense charge. Provided lang yun nga dili mag-double recovery. Okay? Now, kanus aman nga dili pwede or there's no implied institution of civil action. There is no implied institution of the civil action to recover civil liability arising from the offense charge in any of the following instances. Una, when the offended party waives the civil action. Okay, kung iyang gi-waive. Or when the offended party reserves the right to institute the civil action or separately. Okay? Or when the offended party institutes the civil action prior to the criminal action. Okay? In one case, niingon ng Supreme Court nga kung ang criminal action is instituted, ang civil action for the recovery of the civil liability arising from the offense charge shall be deemed instituted with the criminal action. Hence, ingon ang Supreme Court, it is correct to argue that there being no reservation, waiver, nor prior institution of the civil aspect of the criminal case, it also follows that the civil case arising from grave threats is deemed instituted with the criminal action, and hence the private prosecutor may rightfully intervene to prosecute the civil aspect. This is the case of Cruz versus Mina. Okay? Note again that the above rule has no application to independent civil actions under Articles 32, 33, 34, and 2176 of the Civil Code because these actions are by their nature independent. Okay? Timan-ina ninyo, guys. And then, reservation of the civil action. If the offended party desires to reserve the right to institute the civil action after the criminal action has been instituted, the reservation shall be made before the prosecution starts presenting its evidence. Dapat before ni siya sa trial, okay? The reservation is to be made under circumstances that would afford the offended party a reasonable opportunity to make such reservation. Basically, kaning reservation maybe or will be made during the pre-trial. Okay? So, timan ilang pod nga, sige tagbalik-balik, dili na yun na kailangan ang reservation when it comes to independent civil actions. Articles 32, 33, 34, and 2176 may be filed separately and prosecuted independently even without any reservation in the criminal action. What is contemplated in this phrase or in this statement, kaning Section 1A, Rule 111 of the Rules of Court, are those civil action which arise or which arose out of the offense charge. Okay? So, balik-balik na taan na. I think nakuha na ninyo nga concept. Okay, this is the subparagraph B of Rule 111, Section 1. Rule 111, Section 1, subparagraph B, diba? It talks about Batas Pambansa bilang 2022. The Supreme Court has settled the issue of whether or not a violation of BP bilang 22 can give rise to a civil liability. The payee of the check is entitled to receive payment of the money for which the worthless check was issued. Having been caused damage, the offended party is entitled to recompense. Now, with respect to criminal actions for violation of BP 22, it is explicitly clear that the corresponding civil action is deemed included, appeal na, and that a reservation to such or to file such separately is not allowed. Okay? While ang rule nag-allow nga ang offended party pwedeng i-reserve niya ang right to institute the civil action, kani nga katungod does not apply to a prosecution of criminal action for violation of BP 22, kaning bouncing check or law on bouncing checks, okay? The criminal action in this case shall be deemed to include the corresponding civil action. Unya, no reservation to file such civil action separately shall be allowed. And upon the filing of the joint criminal and civil actions, the offended party shall pay in full the filing fees based on the amount of the check involved. So, may bungguro mo nga na may filing fee because here, deemed instituted na ang civil action and under the rules, dunay filing fee ang pag-file og BP bilang 22. And this amount shall also be considered as the actual damages claimed. Oh, so kung bisan pa og makabayad mong filing fee, do not worry about it because inig-award ana sa korte, ma-appeal na ninyo claim as actual damages ang payment of the filing fee, okay? It should be observed that what the rule prohibits is the filing of the reservation to file the civil action arising from BP 22. It does not prohibit the waiver of the civil action or the institution of the civil action prior to the criminal action. Okay? So, ang giprohibit rani is the reservation to file the civil action. It does not actually prohibit the waiver. O, pwede rin mo i-waive ang civil action. Or you can always institute it ahead of time or ahead of the criminal action. And then, what else? Counterclaim, cross-claim, third-party claim in a criminal action. Remember that this is also provided in the rules, Rule 111 of your Section 1. A court cannot entertain counterclaims, cross-claims, and third-party complaints in the criminal action. May ngumon sa din ng counterclaim. Does anyone here have an idea what is a counterclaim? Counterclaim? Do na mo idea, guys? Kahilom ba yung taon ani?
Wag yun din tayo na ni.
Kahilom ba ang mga tawhana?
Is it a rebut, attorney?
Sample daw din.
When someone is ako attorney?
Oh, sige day.
When someone has a claim and then there's a rebut about someone's claim.
Yes. Okay, that's counterclaim. Panalitan ako ning kiha ka nako og libel. Nya me as the accused, ako accused no? Ikaw to ang kuan, ikaw ang complainant. So ikaw ang complainant, kika ko mo libel. My defense is that ikaw man pod nang libel ka nako. So that's practically counterclaim. Gibaslan sa tika og another claim. How about cross-claim? Unsa man ang cross-claim?
Ni file attorney og different case. Not same.
Ang cross-claim mao ni. Panalitan, gikiha ko ni Kate og let's say physical injuries. Ako og si Doc Crispy. Okay? So in this case, co-accused nako si Doc Crispy, di ba? So pagkiha ni Kate, siya kamong duha, kamo moy nangulatan ako inyo kung gisagpa-sagpa dito sa 7th floor. Ako as the co-accused, ning cross-claim ko, dili ako si Dr. Crispy ra. That's basically a cross-claim. Meaning, ang akong claim is against my co-accused or co-defendant. Mao nang cross-claim. How about third-party claim? Third-party claim. Third-party claim meaning, dili siya party to the action. Ako, ang akusado, si Kate ang private complainant, apan pagkihan ni Kate nako, akong gibuhat, nanawag ko glain, akong gibira ang usa ka tawo in order for him or her to be a part of the case. That's third-party claim. Kung dili ako sad-an, kato si Juan de la Cruz ang sad-an and he has to be impleaded in this case. So that's basically a third-party claim. And under the rules, a court cannot entertain counterclaims, cross-claims, and third-party complaints in the criminal action. A criminal case is not the proper proceeding to determine the private complainant's civil liability. A court trying a criminal case is limited to determining the guilt of the accused and, if proper, to determine his civil liability. It cannot award damages in favor of the accused, and a criminal case is not the proper proceeding to determine the civil liability of a private complainant. The rule is explicit when it says that no counterclaim, cross-claim, or third-party complaint may be filed with the accused in the criminal case, but any cause of action which would have been the subject thereof may be litigated in a separate civil action. Okay? So, tanawa lang na ninyo ang rules. And then let's now go to section 4 of Rule 111. Can anybody read this? Kasi pwede mo basaan eh.
Can I, attorney?
Sige day.
Section 4, effect of death on civil actions. So the death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from the delict. However, the independent civil action instituted under Section 3 of this rule, or which thereafter is instituted to enforce liability arising from other sources of obligation, may be continued against the estate or legal representative of the accused after proper substitution or against said estate, as the case may be. The heirs of the accused may be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian ad litem for the minor heirs. The court shall forthwith order said legal representative or representatives to appear and be substituted within a period of 30 days from notice. A final judgment entered in favor of the offended party shall be enforced in the manner especially provided in these rules for prosecuting claims against the estate of the deceased. If the accused dies before arraignment, that the case shall be dismissed without prejudice to any civil action the offended party may file against the estate of the deceased. Hello, attorney. You are muted, brother.
Nawa, day ko. Nisulti para mo kong birthday ni mo, Ophil. Happy birthday,
Thank you, attorney.
Happy birthday.
Wonderful
Birthday.
Birthday, ma'am. Ophil.
Diba? Naningog sila.
Thank you po.
Pero gipawatana ganihawa, naningog. Sige. Who can actually explain this bit? Section 4, effect of death on civil actions. Anyone? Nanihilom na. Uy. So may effect, death of the accused in civil actions. Unahon na to ang effect of death of the accused in his criminal liability. Okay? Ang death of the accused prior to the final judgment or prior to final judgment as when he dies pending appeal of his conviction extinguishes his criminal liability. Kakuha mo, So kung namatay siya, nga wala pa madesisyon ni ang iyahang kaso, or kung namatay siya pending appeal, ang iyahang criminal liability is extinguished. Meaning, wala na. Okay, ang patay na good kinsa pa may imuhang prisuhon, di ba? There's a case that is illustrative of this principle. Here, in the case of People versus Soria, ang accused appellant was found by the Supreme Court guilty beyond reasonable doubt of rape on November 12, 2012. Okay? So, paano siya ha? Convicted na siya beyond reasonable doubt November 12, 2012. The decision supposedly became final and executory on December 20, 2012. Subsequently, however, the court was notified by the Bureau of Corrections that the accused appellant pending appeal of his conviction, died on August 16, 2012. Okay? So nag-una pa ang iyang kamatayon during sa pendency sa iyahang appeal. Okay? When the death was confirmed, the court set aside its decision and dismissed the case. In dismissing the case, the court acknowledged that its decision on November 12, 2012, finding the accused guilty had become irrelevant and ineffectual by reason of his death. The criminal action is extinguished inasmuch as there is no longer a person to stand as the accused. Okay? Question. What naman siya criminal liability, di ba? Na-extinguished because of his death. Now, is his civil liability arising out of his civil, or is his civil liability arising out of the offense charged or out of the criminal action also extinguished?
No. No, attorney.
No, attorney.
No, attorney.
Wala? Diba na-extinguish iyang criminal liability? Does it also extinguish his civil liability arising out of the offense charge?
No, attorney.
No, attorney.
I think yes.
No?
attorney.
No, attorney.
Yes,
Yes,
attorney. Yes,
I think yes.
No, attorney, because
no.
he still has
I think yes, attorney.
he has his attorney, then the court can appoint some legal representative for his ears, so that the offended party can file against his estate to claim attorney for the civil liability. Attorney.
Okay. Kisa to naingon nga yes. Kisa to yung nga no di ay. Yes, man ito mo answer, no? Siglento, no? Kisa to?
No, attorney. I told attorney that his civil liability will still exist.
Okay.
Even if
Existing yapon
yeah.
siyang civil liability bisag namatay siya. Okay.
Yes, attorney.
How about, okay, kisa man to niingon nga wala na siya civil liability arising from the crime, attorney, because namatay na siya. Kisa man to? Si Marvin. Oh, Marvin, why do you say so?
Kay di ba attorney ni nag-explain kaganina nga sa naa siya criminal liability, if there's a criminal liability, there will always be a civil liability. But as to the dismissal of the case, attorney, once the criminal liability will be dismissed, also the same attorney, the civil liability will be dismissed.
Okay, balik ta sa section 4 nga gibasa ni Ophil ganiha ang birthday girl. Tanawan ninyo guys. The death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from the delict. So what's your answer now?
It depends.
Ano na, it depends man.
Will also be extinguished, attorney, together with the criminal offense charge.
Yes, yes. Okay. So ako amang gipangutanog ganiha kani ba nga aspect, di ba, namatay siya. So ngayang civil liability arising out of this criminal liability, will it also be extinguished? The answer is yes, by virtue of section 4 of Rule 111, di ba? If the death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from the delict. Meaning, kani nga criminal action. The source of obligation here is the offense charged. Kanumdo mo? Bago rata naghisgutan eh. Kung ang source of obligation is the delict or the offense charge, pareha raman siya. So, sumpay man siya ani as long as it is still pending or after arraignment and during the pendency of the criminal action, ma-extinguish ang iyang civil liability. Now, lahi ang mamahimong rule kung before arraignment. Okay? Kung before arraignment. So, unsa to'y rule kung after arraignment? If the accused dies after the arraignment and during the pendency of the criminal action, the civil liability of the accused arising from the crime is extinguished. Timan ina guys, this is grounded as it is on the criminal action. The civil liability that is extinguished is that liability arising from and solely based on the offense committed. Okay, tanawa, offense committed. Since the criminal action is extinguished and is in as much as there's no longer a defendant to stand as the accused, the civil action instituted therein for the recovery of civil liability ex delicto is ipso facto extinguished, okay, or by operation of law extinguished, grounded as it is on the criminal case. Now, there's a different rule if the death occurred before arraignment, okay? If the accused dies before arraignment, the case shall be dismissed, but the dismissal shall be without prejudice to any civil action which the offended party may file against the estate of the deceased. This time, adto na kamaningil sa estate sa namatay or sa akusado, okay? Timan ilang guys nga kaning rule, kaning death after arraignment, which actually extinguishes the civil liability of the accused, has no application to independent civil action. Okay? Di ni siya mo apply sa independent civil action and other civil liabilities arising from sources of obligation not arising from the offense charge. Okay? So kung lain ang source of obligation, dili ma-extinguish. What is only extinguished is the source of obligation that arose from the delict or the offense charged. Okay? They may be continued kung independent civil action siya or other civil liabilities arising from sources of obligation not arising from the offense charge. They may be continued against the estate or the legal representative of the accused after proper substitution or against the estate as the case may be. Ang jurisprudence ni ingon gyud nga ang victim, despite the death of the accused, may file a separate civil action against the estate of the deceased accused based on the sources other than the delict. Okay? And remember, in Some, upon the extinction of the criminal liability and the offended party desires to recover damages from the same after remission complained of, the party may file a separate civil action based on other sources of obligation in accordance with Section 4, Rule 111. If the same act or omission complained of arises from quasi-delict, a separate civil action may be filed against the executor or administrator of the estate of the accused pursuant to the rules of court, particularly Rule 87, Section 1. Okay? Conversely, if the offended party desires to recover damages from the same after remission complained of arising from contract, the filing of separate civil action must be filed against the estate, also pursuant to the rules of court, Rule 86, Section 5. So basically, kung other sources of obligation, ang iyahang civil liability, mo proceed na even after his death. But if it is a civil liability arising from the delict or arising from the offense charge, and then it occurred after the arraignment and during the pendency of the criminal action, well, that civil liability is also considered extinguished. Okay? I hope klaro na guys? Ribog mo.
So, bali, attorney, it's a yes and no, attorney.
Okay, ano yes and no?
If the accused dies before arraignment.
Yes, for the...
Attorney, what happened to the injured party? Wala.
Civil action which the offended party may file against the estate cases.
Yes, attorney. Yes, for the delict offense, it is extinguished. Yes, but for the offense under 32, 33, 34, and 2176, it is not this deleted,
yes.
attorney.
Yes.
So yes and no.
Yes and no. Okay.
And attorney, I have a question, attorney. What if, attorney, another case, if the accused party wins the case, attorney, can he file after the case? Can he file a countersuit, attorney, to the accuser?
Pwede. Kumuhi pa siya.
Can he file still a criminal and a civil case?
Yes, kumuhi pa siya.
Okay.
Attorney, kanibang effect of death of the accused on his civil liability kaning death before arraignment? The civil liability, does this refer to independent civil liability or
the delict?
Civil liability which is
and other sources of obligation. Kay wala pa man na-start ang iyahang criminal liability before pa man sa arraignment. So if mamatay siya before the arraignment, ang ma-dismiss raani is the criminal liability. But this is without prejudice to the civil action nga pwedeng ipadayon ni offended party against the estate sa akusado. So the extinction of civil liability arising from delict will only happen after arraignment and during the pendency of the case. Okay? But if pananglitan, namatay siya, final judgment na, executory na ang decision sa korte, o niya na-awardan na sa civil liability, bisan pag mamatay si akusado, still the estate will be liable for the civil liability. Kaya di naman pending ang kaso. Kakakuha mo?
Yes, Tony.
Wala, no?
Huwag diri, minalibo ganito ni.
Balik. Tanawa niya rule. Death after arraignment. Kung akusado namatay after arraignment and during the pendency of the criminal action, pending pa gani, meaning di pa final and executory ang desisyon sa korte. Meaning nag-apelar pa na or nagkaso pa gihapon na, trial pa ba ng kasuha, okay? Namatay ang akusado. extinguish ang criminal liability, of course, because kisa pa may mong prisuhon, di ba? And it also follows with it the extinction of the civil liability arising out of that criminal liability. Okay? Pero kung civil liability nga gikan sa other sources of obligation, let's say independent civil action, or let's say ang iyang other civil liability is arising out of quasi-delict, dili na siya ma-extinguish. Okay? Bisan pa man og mamatay siya during the pendency of the action. Now, kung ano ito diri sa before arraignment meaning na-file na siya kaso, pero pa siya na-arraign, namatay siya before the arraignment. What is only extinguished here is the criminal liability. Why labot ang civil liability arising of the offense charge and other sources of obligation. Kakuha mo?
Ang tanan gidi ay attorney.
Oh, tanan. So tanan, iyang civil liability nga ni arise from the criminal liability and other sources of obligation dili ma-extinguish. And you can always claim from the estate of that accused nga namatay na. What?
Attorney, good evening, attorney. Question, attorney.
Yes.
What if attorney ang accused attorney walay estate, still the offended party can kuan attorney?
Kung wala siya katigayunan, low jud kayo ang offended party kay wala naman siya mapaningil.
Yes, attorney.
Mao na ang sad life. Wala siya mapaningil. So, if you want to pursue the civil liability, you have to check first and ensure first nga doon ay mga katigayunan na habilin or property na habilin ang akusado. Kung wa gani, it's a lost cause. So, ay na lang katuga-tuga, gasto-gasto ra ka. Kay nabiyan ni filing fee ang civil action.
Okay, attorney.
Dili na lang.
Thank you, attorney.
Attorney, pwede mong utana?
Sure.
Oh, actually, namong good case ba na kanang utangan ako sa farm. Nya, Mr. Zabalan, attorney. Oh.
Okay.
Nya kanang naka-receive siya, gipadadaan ako siya demand letter na acknowledge siya na receive niya. After a week na COVID siya din namatay. Ang wife ang tigiya sa farm ba. The amount is medyo dako mga 2M.
Uy.
Lagi so karon among gipaningil ang husband so na may chance na ma-file na namo og ano kana.
Yes, ang estate pwede.
Okay. So we need a lawyer or pwede na kami mo diretso dito sa korte?
You need a lawyer.
lagi giingon lagi. Anyway, thank you, attorney. Thank you. At least I have an idea ang saan ako pag ano.
Sige. Okay. Sige. Namang konsulta na lang taan eh. Lang ta mag-discuss ha. Let's proceed to kaning concept of novation. Kaya ba mo unsa nang novation? You will also discuss this in your obligations and contracts. That's actually next next semester. Ang novation will not extinguish the criminal liability, okay? It is best to emphasize that novation is not one of the grounds prescribed by the revised penal code for the extinguishment of criminal liability. Kaya ko layo pa kayo mo sa extinguishment of criminal, asa na mo dapitron sa inyong criminal law 1? Article unsa na mo?
Kuan pa mi mitigating pa mi ito ni.
Mitigating, that's Article G.
Napami sa
13, attorney.
13 na? 13. Okay. Mitigating. Na namuriha. Layo pa kayo mo sa extinguishment of criminal liability. Remember that in your revised penal code, what gyud diha nalabot ang novation as one of the forms of extinguishing a criminal liability. Unsa man dining novation? Novation under Article 1293 of the new Civil Code is an act of substituting a new debtor in the place of the original one. It may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. Payment by the new debtor gives him the rights mentioned in Articles 1236 and 1237. Basically, ang novation, na-change ang nature sa obligation. Either na-change ang parties or na-change ang nature sa obligation. And niingon ang balaod nga ang jurisprudence niingon nga ang novation is not one of the grounds to extinguish a criminal liability. And in the case of Metropolitan Bank and Trust Company versus Reynaldo, niingon ng Supreme Court nga it was ruled that criminal liability for estafa is not affected by a compromise or novation of the contract. Okay? Because in your practice unya later on makabaw mo nga kung naay criminal liability between the parties, panalitan ako, nakautang ko ni or nakadispal ko, let's say og kwarta kang kisag itong nota na ganihan na 2 million si kinsa man to nakalimot ko si Labala.
Balan to ni
si Jeremiah. Nakadispal ko kon Jeremiah og 2 million and iya kong ikiha og let's say example lang staffa. Unya nihangyo kong Jeremiah ayaw lang sa akong palikas, so I will just enter into a compromise. Meaning mo enter ta into a memorandum of agreement or a memorandum of compromise wherein I will promise that I will pay you the amount of 2 million pesos monthly for a period of 1 year. Okay? So kana bali nanami bag-o nga kasabutan. But in this case, niingon ng Supreme Court, even if there's compromise, the crime of staffa, in the crime of staffa, ang reimbursement or belated payment to the offended party of the money swindled by the accused does not extinguish the criminal liability of the said accused. Also, criminal liability for staffa is not affected by compromise or novation of the contract, for it is a public offense which must be prosecuted and punished by the government on its own motion, even though complete reparation should have been made of the damage suffered by the offended party. And staffa, reimbursement of or compromise as to the amount misappropriated after the commission of the crime affects only the civil liability of the offender and not his criminal liability. So the same is true na ako'y kaso nakasuhay ko ani BP22. I have a client, my client is the private complainant. Gamay ra gud giutangan siya og mga 900,000 pesos sa iyahang amiga. Unya ni-issue og cheque, niuntol ang cheque. So iyang gibuhat, iyang gipatawag sa barangay. Pagpatawag na niya sa barangay, nagkasinabot sila nga bayran siya og monthly. But after 2 months, ni-default man niyang amiga. So ang iyang gibuhat is to proceed into filing BP22. So ni-file mig BP22 and then we actually won the case. We were awarded by the court nga niingon ng korte, mapriso ka kung di ka mobayad ani nga na so and so. And then the defense of the accused is this, niingon siya, since there was already novation because of the agreement entered into by the private complainant and the accused in this case, wala na'y katungod si private complainant kuno nga mo file og BP bilang 22. The court said, iya gining gi-cite nga kaso kaning Metropolitan Bank versus Reynaldo nga the novation is not one of the grounds prescribed by the revised penal code for the extinguishment of criminal liability. And in this case, wala gyud ma-overturn ang decision sa trial court because of the defense interposed by the accused in this case nga nakunoy kasabutan ang akusado o ang private complainant. So remember that novation is not a form or is not a ground for the extinguishment of a criminal liability. Are we already done with sections 1 to 4 of Rule 111, and we now continue with sections 5 to 7. Hopefully, mahuman din nato. Just please reserve your questions for later ha. Ako lang ning lahoson natong discussion so that mahuman gid nato karon nga meeting, and next week we can start with preliminary investigation. So I'll start now with section 5, judgment in civil action, not a bar. So remember that a final judgment rendered in a civil action absolving the defendant from civil liability is not a bar to a criminal action against the defendant for the same act or omission subject of the civil action. So kung example guys, ang defendant is absolved of a criminal or of his criminal liability or of his civil liability in a civil action, can a criminal action still be filed against him? For example, si Sir Seferino instituted a civil action beforehand and it was dismissed later on. Can a criminal action still be filed by him against, let's say, X? Pwede pa? Under this
Yes.
section, the answer is yes, di ba? While it may be true that every person criminally liable is also civilly liable, the converse is not true, okay? Therefore, even if ang defendant in that example nga kung giingon ninyo is absolved of his civil liability in a civil action, a criminal action can still be filed against him because the outcome of the civil action is not in any way determinative of the guilt or innocence of the respondent or defendant in the civil case. So, also remember nga, in a criminal action, ang party here is the state. And in a civil action, the private offended party ang mahimong party in that civil action. So, di gyud mamahimong bar ang judgment or let's say final judgment in a civil action dismissing or absolving the defendant of his civil liability in a criminal action against the said defendant. Okay? Also, ato nang nahisgutan gapon, ay di gapon itong Tuesday, na the quantum of evidence required in a civil action is different from that of criminal action. Unsa toy quantum of evidence required in a civil action, guys?
Preponderance of evidence.
Yes, preponderance of evidence. While ang criminal action, ang iyahang quantum of evidence required is, unsa to?
Beyond reasonable doubt.
Proof beyond reasonable doubt. That's correct. Very good. Okay, so that's section 5. Section 6 and 7, let's read this together. This pertains to prejudicial question. Suspension by reason of prejudicial question. Now, Section 6 provides that a petition for suspension of the criminal action based upon the pendency of a prejudicial question in a civil action may be filed in the office of the prosecutor or the court conducting the preliminary investigation. When the criminal action has been filed in court for trial, the petition to suspend shall be filed in the same criminal action at any time before the prosecution rests. Now, what are the elements of prejudicial question? The elements of prejudicial question are the following. Una, tanawa ni, previously instituted civil action. Previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. Ikaduha, the resolution of such issue determines whether or not the criminal action may proceed. Now, unsa man di concept aning prejudicial question? In your book, you've already read this. A prejudicial question is understood in law to be that which arises in a case, the resolution of which is a logical antecedent of the issue involved in a criminal case, and the cognizance of which pertains to another tribunal. It is determinative of the criminal case, mo determines a criminal case, but the jurisdiction to try and resolve it is lodged in another tribunal. Meaning, separate cases ni. Separate ang korte ni civil, separate sad ang korte ni criminal. It is based on a fact distinct and separate from the crime, but is so intimately connected with the crime that it determines the guilt or innocence of the accused. The concept of prejudicial question comes into play when a civil action and a criminal action are both pending, and there exists in the former, meaning in the civil action, an issue which must be preemptively resolved before the latter case may proceed because the resolution of the civil action is determinative of the guilt or innocence of the accused in a criminal case. Unsa may rason nganong mo adhere ta to the principle of prejudicial question. The reason behind this principle is to avoid two conflicting decisions in the civil case and in the criminal case. Now, to have a better understanding of the concept of prejudicial question, let's try to watch this video, guys. Okay.
Layon ng programang relasyon na makapagbigay ng payo na naaayon sa batas. Para higit na maliwanagan sa terminong legal, narito ang ating Word of the Day.
Ang ating word of the day po ngayon ay prejudicial question. Anong ibig sabihin niyan? Issue na dapat sagutin sa civil case bago isulong ang criminal case.
Okay.
Alam mo, Gladys, sa ating court procedures, pwede kang idemandang kriminal at yung ginawa mo, may repercussion ring civil.
Okay.
O halimbawa na lang, Gladys, yung pag ipoprobate ng will, parati natin napapag-usapan yan. Kasi po ang last will and testament, hindi po magiging mabisa yan kung walang approval ng korte. At ano ang inaaprubahan ng korte? Na yung last will and testament ay siyang ang ginawa nung tinatawag na testator, yung namatay. Siya ang gumawa. So halimbawa po yung namatay si X, may anak na A, B, C, D, and E. Tapos si E ang may hawak nung last will and testament. So ipinaprobate niya na. Ngayon, si A, B, C, D, kalaban nila si E. Ang paratang nila, yung pirma nung namatay nilang tatay ay pineke ni E. So, nag-file ngayon sila ng falsification of private document. Okay? Sapagkat nga, si E, pineke yung pirma ng tatay nilang yumao according to them. So, may criminal case na ng falsification of private document na pwedeng makulong si E, pwede pang magmulta, at pwede pang magbayad ng bayad perwisyo. So, isa dyan, yung probate case, tawag doon civil case.
Okay.
Yung criminal case, yung falsification. Doon makukulong ka, yung isa, magbibigay ng manahan. So, halimbawa, ang issue sa probate case is, totoo bang pinirmahan ng yumao ang last will and testament? Ang issue naman sa falsification totoo bang pineke ni E yung last will and testament, yung signature? So makikita mo, Gladys, magkakabit yung dalawang kaso.
Yes.
Isa criminal, isa civil. Para sa orderly administration of justice, tinatawag yan na prejudicial question. Yung tanong sa civil case, maaaring maging prejudicial sa criminal case.
Okay.
Kasi kung sabihin ng korte, ayon sa ebidensya, ang pirma ng testator sa last will and testament na ito ay genuine.
Okay.
Totoo. Yung mga testigo, matagumpay nilang napatunayan na ang pirma ng namatay at yumao ay totoo. So anong mangyayari doon, Gladys? Wala nang silbi yung criminal case. Ibibigay na lang yung decision ng decision sa civil case doon sa criminal case at yun ay didismiss na. Kaya nga kung ganun nagkasabay yung criminal case at civil case at ang issue sa civil case ay dapat sugutin bago sumulong ang criminal case, sinususpend muna ang criminal case. Huwag munang itutuloy, hintayin ang matapos ang civil case.
Okay.
Kaya yan ang prejudicial question.
Is it always that sasagutin na issue sa civil case bago isulong ang criminal case or pwedeng it's the other way around, prejudicial question din, from criminal to civil?
Parating ganon.
Parating ganon, okay.
Sapagkat ang pag nangyari sa criminal case ay kulong.
Oo.
Diba? Kulong yun. Matindi ang endpoint.
Okay.
Pero ang civil case, hindi masyadong matindi. Lighter. Sinasabi mo lang kung ano yung totoo o hindi. So, dapat ayusin muna yung lighter, yung civil case, bago sa isang matinding kaso na ang parusa ay pwedeng kulong ka.
Okay.
So, kaya ang parating na sususpend ay yung criminal case.
Okay. So, yan po ang ibig sabihin ng prejudicial question.
That's right.
Okay, so unsa toy elements sa prejudicial question? It's stated in your section 7 of Rule 111. The elements are as follows: that there be a previously instituted civil action involves, or the previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and the resolution of such issue determines whether or not the criminal action may proceed. I think inyo tong nasabtan with the explanation of Dean Santa Maria, no? So for a civil action to be considered prejudicial to the criminal action, kailangan na ani ang mga following requisites. Okay? Una, the civil case involves facts intimately related to those upon which the criminal prosecution would be based. Ikaduha, in the resolution of the issue or issues raised in the civil action, the guilt or innocence of the accused would necessarily be determined. And then third is that the jurisdiction to try the said question must be lodged in another tribunal. So kaning section 7 of Rule 111 presupposes the existence of two actions. Sama sa giingon ganiha ni Dean Santa Maria. Ang usa, civil, and the other, criminal. So, walay mahitabo nga prejudicial question kung ang duha ka kaso nga nag-ung-ung puro criminal, or ang duha puro civil, or puro administrative case, or ang usa kay administrative, ang usa civil, or kung ang usa administrative, ang usa criminal. Kailangan in a prejudicial question, there has to be a previously instituted civil action. Ang ikaduha na ay subsequent criminal action. Okay? So a prejudicial question cannot be appreciated where the subject actions are all civil in nature. That's provided in Strategic Alliance Development Corporation versus Star Infrastructure Development Corporation. Also, in the same section, kaning section 7, this also states that even if one case is civil and the other is criminal, the principle of a prejudicial question will not arise if the criminal case instituted or was instituted prior to the civil case. Nga naman, kay klaro kaayo ang naaaning section in section 7, it states that it has to be previously instituted. It has to be a previously instituted civil action. That the civil action must have been instituted ahead of the criminal action is confirmed by the same rule which makes reference to a subsequent criminal action. Also, this section presupposes that the issue that led or that leads to a prejudicial question is one that arises in the civil case and not in the criminal case. Okay? Klaro sa to ganiha sa gidiscuss ni Dean Santa Maria. It is the issue in the civil case which needs to be resolved first before it is determined whether or not the criminal case should proceed or whether or not there should be in the criminal case a judgment of acquittal or conviction. And another vital element of prejudicial question is one which has something to do with the issues involved. It is worth remarking that not every issue raised in the civil action will result in a prejudicial question. The rule clearly implies that it is not enough that both cases involve the same facts or even the same or similar issues to make the civil case prejudicial to the criminal case. The mere claim that the issues in both cases are intimately related will not necessarily make the issue in the civil case prejudicial to the resolution of the issue in the criminal case. It is critical to show that the issue in the civil case is determinative. That's the operative word, ha? It has to be determinative of the issue in the criminal case. Para sa example ganihan ni Dean Santa Maria, nga kung ma-determine na ang guilt or innocence of the accused in the civil case, then kailangan i-resolve na siya in the civil case, katong probate ganiha o ang katong falsification. So in that instance, since in the probate, napasar naman sa court nga ang pirma sa testator is valid and it was obtained legally, wala gi-falsify, then katong criminal case of falsification will no longer hold water because the issue or the decision of the civil case was actually determinative of the issue in the criminal case. In other words, or in the words of the rule, the resolution of such issue determines whether or not the criminal action may proceed. Mo nang concept sa prejudicial question. Okay? Now, also to effect sa prejudicial question, there will be a suspension of the criminal action based on Section 6, Rule 111 of the Rules of Court. So under this section, niingon nga petition for the suspension of the criminal action based upon the pendency of a prejudicial question in a civil action may be filed. Under the clear terms of Section 6, the filing of a petition before the suspension of the criminal action is required. So kailangan mo file ka og petition for suspension of the criminal action, okay? The rule, therefore, as it appears, precludes a motu proprio suspension by the court of the criminal action. So, dili automatic nga there will be a suspension. Kailangan the party has to apply or has to file for a petition to suspend the said criminal action. Okay? The need for the filing of a petition finds support in jurisprudence, which declares that since suspension of the proceedings in the criminal action may be made only upon petition and not at the instance of the judge or the investigating prosecutor, the latter cannot take cognizance of a claim of prejudicial question without a petition to suspend being filed. So kailangan there has to be a petition, ha? Take note of that. Since a petition to suspend can be filed only in a criminal action, the determination of the pendency of a prejudicial question should be made at the first instance in the criminal action and not before the Supreme Court in an appeal from the civil action. That's in the case of IBP versus Atienza. Another effect is that it also needs to be stressed that when there's a prejudicial question, the action to be suspended is the criminal, ha, and not the previously instituted civil action. Klaro na ganiha sa discussion ni Dean Santa Maria. When there is a prejudicial question, the criminal case may be suspended pending the final determination of the issues in the civil case. A prejudicial question accords a civil case a preferential treatment and constitutes an exception to the general rule that the civil action shall be suspended when the criminal action is instituted. The general rule provides that if the civil action was commenced before the institution of the criminal action, the civil action shall be suspended in whatever stage it may be found before judgment on the merits once the criminal action is commenced. The suspension shall last until final judgment is rendered in the criminal action. A prejudicial question in this instance is an exception to this rule. The principle of prejudicial question is not within the ambit of this general rule under the Section 2 of Rule 111. So this is basically the exception to the general rule, ha, ang prejudicial question. Now let's go to the case illustrations. The case of People versus Pimentel, okay? In this case, gi-illustrate sa Supreme Court nga ang prejudicial question or principle of prejudicial question do not apply or does not apply in this case. Ang nahitabo man gud here is that ang private respondent filed an action for frustrated parricide against the petitioner, okay? Private respondent filed an action for frustrated parricide against the petitioner. Several months after, the private respondent, ibutang talang si private respondent dire kay si, wait lang, ngita ta. Si Akim ang private respondent. And then the petitioner in this case is Bernadette. Okay, let's just try. So, in this case of Pimentel versus Pimentel, si Akim filed an action for frustrated parricide against Bernadette. Several months after, si Akim filed an action for the declaration of nullity of their marriage. Okay? So, una ha, ning file si Akim o frustrated parricide against ni Bernadette. Unsa gani ng parricide?
Parricide.
Unsa gani ng parricide, guys?
Killing a family member.
Killing
the husband or the wife.
Immediate family.
Yes,
Killing of immediate family, attorney.
Yes, when you kill, kung ba yung kag-parricide, it's when you kill your husband, your wife, or your father, your mother, or your children. Okay?
Any relatives, attorney?
Dili any relative. Para na siya, ascendant, descendant, and then your spouse. Muna basically. So, let's say, kunya, kung imo nang patyon imong asawa, imong bana, that's parricide. Okay? Maura na siya ang di nimo kadugo nga na-include diha sa parricide. So basically, si Akim in this case, ning file action against Bernadette for frustrated parricide. So meaning, wa siya nayatap, so frustrated man. And then several months after, si Akim filed an action for the declaration of nullity of their marriage. So iya ipa-declare as null and void ang ilang kaminyoon. So si Bernadette then filed an urgent motion to suspend the proceedings with the court where the criminal case was pending on the ground of the existence of prejudicial question. Ningos Bernadette nga since ang amuang relationship between Akim and between the offender and the victim is a key element in parricide, the outcome of the civil case would have a bearing in the criminal case filed against me. Ingon siya. So, since the relationship between the offender and the victim is a key element in parricide, ingon siya kay ang mahugram ko nagparricide, kung minyo mao na key element sa parricide, ingon siya. So ang outcome aning nullity of marriage would have a bearing in the case of frustrated parricide filed against me. So when the case reached the Court of Appeals, niingon ang korte, the court concluded against the existence of a prejudicial question. Niingon ang court, wala prejudicial question. Niingon ang korte nga, in a criminal case for frustrated parricide, the issue is whether the offender commenced the commission of the crime of parricide directly by overt acts and did not perform all the acts of execution. You remember this in your criminal law, di ba? Unsa tong frustrated, attempted, o unsa tong consummated. Kinamdo mo? So ang issue, kung maingon ng Court of Appeals, ang issue when it comes to frustrated parricide is whether the offender commenced the commission of the crime directly by overt acts and did not perform all the acts of execution by reason of some cause or accident other than his own spontaneous desistance. On the other hand, ang issue kuno sa civil action for annulment of marriage is whether the petitioner is psychologically incapacitated to comply with the essential marital obligations of the marriage. The Court of Appeals continued that even if the marriage between Akim and Bernadette would be declared void, it would be immaterial to the criminal case because prior to the declaration of nullity, the alleged acts constituted the crime of frustrated parricide had already been committed. And all that is required for the charge of frustrated parricide is that at the time of the commission of the crime, the marriage is still subsisting. So it reached the Supreme Court, and the Supreme Court sustained the conclusion of the Court of Appeals. And it added the reason that the facts show that the criminal case was filed ahead of the case for declaration of nullity. So nabantayan pa yun na sa Supreme Court. Nag-una man ang frustrated homicide, so it already follows nga di na gyud na musud ang prejudicial question. Kay di ba in a prejudicial question, unsa may una, there has to be a previously instituted civil action. Okay? The rule is clear niyo ng Supreme Court. The rule is clear that for a prejudicial question to exist, the civil action must be instituted first before the filing of the criminal action. As such, the requirement of Section 7, Rule 111 of the Rules of Criminal Procedure was not met since the civil action was filed subsequent to the filing of the criminal action. The Supreme Court also added that the resolution of the civil action is not a prejudicial question that would warrant the suspension of the criminal action. Further, niyo ng Supreme Court nga while the relationship between the offender and the victim is a key element in the crime of parricide, the issue in the civil case is not similar or intimately related to the issue in the criminal case for parricide. Niyo ng Supreme Court nga the issue in the civil case for annulment of marriage is whether the petitioner is psychologically incapacitated to comply with the essential marital obligations. The issue in parricide is whether the accused killed the victim. And in this case, since the petitioner, si Bernadette, was charged with frustrated parricide, the issue is whether Bernadette performed all the acts of execution which would have killed Akim as a consequence, but which nevertheless did not produce it by reason of causes independent of Bernadette's will. At the time of the commission of the alleged crime, si Bernadette kuno ug si Akim were still married, and the subsequent dissolution of their marriage, in case the petition in the civil case filed by Akim is granted, will have no effect on the alleged crime that was committed at the time of the subsistence of the marriage. In short, even if the marriage between Bernadette and Akim is annulled, si Bernadette in this case could still be held criminally liable, since at the time of the commission of the alleged crime, siya was still married to Akim in this case. Okay? I hope that's clear. That's Pimentel versus Pimentel. Another case is the case of Maestrado versus People. Thank you, Doc, for sending the definition of parricide. Yeah, here's the definition of parricide. Nasa inyong chat box. This is committed by any person who shall kill his father, mother, child, whether legitimate or illegitimate, or any of his ascendants or descendants, or his spouse. Take note nga sa parricide, ang di ra gyud nimo kaduguan niya, imo yung asawa or imong bana. Okay? The rest, mao ni siya ang ascendants, descendants, mother, father, or child, or grandchild, grandchildren, or grandparents. Okay? Mao man ang ascendants, grandparents, or great-grandparents. Descendants, grandchildren, or great-grandchildren. These are of direct line. These are individuals within your direct line. Okay? Pero ang brother or sister, parricide na. If you kill your brother or your sister, can you be prosecuted for parricide?
Yes, attorney.
Yes, attorney.
No, it's not included in the enumeration of parricide, guys. Ang parricide direct ra siya ang imuhar ng papa, imong mama, imong child, imong grandchild, imuhang apuhan or imong great apuhan. Kanang direct line na pataas o paubos. Mora na ang kanigong brothers or sister, collateral man na sila, pakilid inyong relationship, anak. So if you commit a crime against your brother or sister, that could either be homicide or murder, as the case may be, depending on the elements. Okay, so if you kill your spouse or if you try to kill your spouse, that could either be attempted, frustrated, or kung namatay na yun siya, parricide. Okay, so basically that's parricide. Let's now continue with Maestrado versus People. In this case, the private respondent, si kuan lang gihapon atong private respondent diri, si Akim. Si Akim filed a criminal complaint for perjury against Bernadette for executing an affidavit of loss of a certificate of title of the parcel of land, despite allegedly knowing that no loss of the certificate occurred, because si Bernadette had actually delivered the same to Akim as security for a loan which Bernadette contracted from Akim. Okay? After an information for perjury against Bernadette was instituted, ning file si Bernadette a motion for suspension of the proceedings based on a prejudicial question. Ningon siya nga a case filed against her by Akim for recovery of sum of money is pending before another court. Ningon siya further nga ang kananga civil case is also pending, or another civil case is also pending before another branch of the same court when Bernadette filed against when Bernadette filed against Akim a complaint for cancellation of mortgage, delivery of title, and damages. So the issues kuno in the said civil cases, according to Bernadette, are similar or intimately related to the issues raised in the criminal action. So, ang Supreme Court on the issue as to whether it was proper to suspend the criminal case in view of the pending cases observed that the pending cases are principally for the determination of whether a loan was obtained by the petitioner from the private respondent. In this case, a loan was obtained by Bernadette from Akim, and whether Bernadette executed a real estate mortgage in favor of Akim. On the other hand, ang criminal case kuno involves the determination of whether the petitioner, or here Bernadette, committed perjury in executing an affidavit of loss to support her request for the issuance of a new owner's duplicate copy of the certificate of title. The Supreme Court went on to hold that it is evident that the civil cases and criminal cases can proceed independently of each other. Regardless of the outcome of the two civil cases, it will not establish the innocence or guilt of the petitioner in the criminal case for perjury. The purchase by petitioner of the land or his execution of a real estate mortgage will have no bearing whatsoever on whether petitioner knowingly and fraudulently executed a false affidavit of loss. So that's basically the concept of prejudicial question. In this case, walay prejudicial question ingon ang Supreme Court kay lahi ra jud kayo na nga issue, and it will not establish or it will not determine the innocence or guilt of Bernadette in this case for the criminal case filed against her. Now, also note, last topic, also note that an independent civil action does not operate as a prejudicial question, okay? An independent civil action proceeds independently of the criminal action. Hence, a civil action based on defamation, fraud, physical injuries may be independently instituted of the criminal action. Because of the above rule, an independent civil action based on fraud initiated by the defrauded party does not raise a prejudicial question to stop the proceedings in a pending criminal prosecution of the defendant for estafa through falsification. This is because the result of the independent civil action is irrelevant to the issue of guilt or innocence of the accused. Okay, so that's sections 5 to 7. We are done with Rule 111. Do you have any questions? Sabot Ramos concept sa prejudicial question?